Hello.
Hello?
We are live on YouTube. I have Ian, Ricardo, Aaron, and Tim's office in the waiting room. Are you ready for them all?
I am ready. Let me.
You hear us, Judge?
I can hear everyone. Now I cannot see Aaron. Is Aaron in the process of
I'm
joining?
here. I'm letting Ian do his thing unless he needs some help.
All right. In that case, 69th District Court's in session. I will call case number 6014, the state of Texas versus Ricardo Rodriguez. I understand there are some issues over redaction of videos. Mr. Marable, I'll state for the record that Mr. Marable has brought me a thumb drive with some statements on them. Mr. Marable, I'll let you proceed.
Thank you, Your Honor. As previously mentioned, yesterday we did have a few redactions that we were working with defense on in order to make sure due process was followed and stuff like that. I just got notice from defense that this might be a bit easier. There are 1, 2, 3, 4, 5 pieces of media, I think, that were issued to begin with. I just talked with defense and I'll check with them now on the first one at issue, which is the Rodriguez confession file with Ranger Philip Ditto. From my understanding, for the record, I believe that we've agreed that the entire audio for that be allowed in. I'll let them express if that's correct or not, but that was my understanding.
And this, for my information, this is just an audio. There is not a video with it. Is that correct?
That's correct, Your Honor. And I don't know, am I understanding everything correct, Dan and Tim?
Yes.
Okay.
Right. So the parties agree that the Rodriguez confession will be allowed in its entirety should the parties decide to ask that it be admitted. Is that correct?
Yes, Your Honor.
All right. What about well, I'll just let you proceed, Mr. Marable.
Yes, Your Honor. There was a Nancy Zubia in-car video at which we have agreed to mute the sound from 247 to end at the defense's request. We agreed to that. So that's the next one, and that was the only request on that one.
All right. So that's the Zubia body cam.
Sorry, that's the in-car, Your Honor.
Oh, I have a BC, but that's an in-car.
Yes, ma'am. I don't think I gave you that one since we have an agreement on it.
Oh, got you. Okay.
Next up, we had possible issues with Jeffrey Baker body camera. This one, I do believe that there's possible dispute as to exactly what's going to be cut and what's not going to be cut. I think the court might have to review this with us in order to make a determination on exactly what we're going to do. Defense counsel has made 3 requests. I'm looking at it now. It appears as though they want to first cut all audio before 2 minutes, mute all radio traffic, and cut after, and I think we've agreed to extend that to 7:29. Do we have an agreement on that one?
I don't see an issue with it.
Okay. So we agreed to cut all body cam after 7:29, but what we're having an issue with is whether or not to cut all audio before 2 minutes and to mute all radio traffic. And I have the state's position on that as well. We would like the radio traffic to come in. I believe that the defense is trying to keep the radio traffic out. It might be appropriate to review the video or view the video with the court first in order to make a determination before arguments. I don't know.
All right, this is the Baker body cam,
Yes, Judge.
correct? Okay. I'm going to pull it up on this screen, see if I can. Right, this is playing. I'm not hearing any audio. Should I be?
And I would note that it probably will start
I think I see my set my way a good ways away.
No, I'm sorry. What did you say, Mr. Marable?
I was just going to point out that the body cam doesn't start recording audio instantly.
Okay, here we go.
But
So is that, right there at double E?
at double
You know what,
E, Aaron said somewhere else. I'm way past double E.
Yeah, no, he's gonna set up spike for double E. It's 291 or whatever, but it's double E. So our boss is coming in here, me with you to set up spikes over there.
All right, then I'm on the way back. Then, bye.
You have my boss number?
Yeah. Bye.
All right, that's the 2-minute mark. Is
Yes.
that the disputed 2 minutes?
I believe so. I think there's a conversation between Officer Jeffrey Baker and I believe it's Nancy Zubia relating to spikes or something to that nature. The state would make the argument in this case that these communications are not hearsay at all. Rather, they're being used to establish that a communication took place to provide context for the actions taken by the officers involved. Whereas hearsay is normally a statement made out of court that's offered to prove the truth of the matter asserted. In this case, the communications not being introduced for that, it's being used to demonstrate what information was available to officers at the time and how they responded to it. Therefore, I would make the argument that this conversation between the two should be allowed. Additionally, both these officers are going to be available to testify in this case. I don't see any issue with these statements coming in at this time.
Response, Mr. Seeloff or Mr. Sally?
No, our only response would be that they are being offered to prove the truth of the matter asserted. He said they're used to gain information. Well, that's the information they're gaining is the truth of the matter asserted. However, Judge, I don't think we really care if this comes in or not. So we're going to go ahead and just waive our objection on that.
All right, the first 2 minutes then will be allowed should a party decide to ask that it be admitted. And then what, was there an additional dispute on this body cam video?
I believe there's radio traffic afterwards, Your Honor. So after the 2 minutes, and I think it'll go all the way up to 7:29. So I'm not sure exactly where you are on the video, but it should go up to about 7:29 from where you're at.
All right. I was at 2 minutes.
You know, right? Okay, good. Hey, what's your name? Hey, what's your name? Thank you.
That's 7:27.
Okay, thank you, Your Honor. I believe that what's at issue here is the radio traffic that's being involved. Here, the defense wants it out, and I believe this is going to be the issue with Estrada and Zubia's body cam as well. I think this is the primary issue that we're dealing with today. Again, I'd make.
Excuse, counsel, we've lost Mr. Ricardo,
Oh,
Rodriguez. He just went away.
okay.
Mr. Sally, can you try to contact him and get him back?
We will, Judge. I noticed he was driving somewhere, it looked like, so he may have lost his signal.
Judge, with that specific video, we don't have any objections.
Up until this 7:28 point? No
Okay.
objections, or to the whole video?
To the 7:29, we'll have no objections.
Okay,
We have no disagreement with cutting after 7:29, Judge.
all right. Then I will make a note, if it's asked to be admitted at trial, that anything up to 7:29 is okay. Everything after that is cut.
I do think we probably should still wait for the defendant.
I agree.
Nope. Mr. Rodriguez, can you start your video, please? Mr. Rodriguez? Mr. Rodriguez, can you unmute your microphone, please? I think if you hit *6 on your phone, it will open your microphone. Mr. Rodriguez, can you hear us?
Ricardo, can you try tapping the unmute on your phone? When you're on the Zoom screen?
Can I try that?
No, Ricardo, I'm sorry.
Oh,
Ricardo, can you hear us? If you can, shake your head up and down. No, he can hear us, Judge. I don't know that we need him unmuted to continue.
Can you see your lawyer on the screen, Mr. Rodriguez?
No, he can see us. I think we can go, Judge. We don't necessarily need him unmuted.
right, Mr. Rodriguez, I'm just going to ask if you want to say something, raise your hand where we can see it. And otherwise, I'll proceed. While you were gone, the parties agreed, your attorney and the prosecutor agreed that all of Mr. Baker's body cam recording would come in until the 7-minute, 29-second point, and after that would be cut.
Yes, and as long as it's that video, Judge, we're okay with it. The one that we just viewed now, we are okay with it.
Okay, say that again, Mr. Seelow. The Baker body, we're
Video.
talking about the Baker body
Dan,
video.
Dan, move closer to the microphone.
Can you hear me a little better now, Judge? I apologize.
Yes, what did you say about the Baker body cam video?
As long as it's the video that we all just saw in the court, we are okay with allowing that in.
All right, any response to that, Mr. Marable, or is that acceptable?
That appeared to be the Baker body cam video, so yes, I think that's fine.
All right, so you may proceed. There's one more video, the Sergeant Aaron Estrada one.
I think there might be two, Your Honor. We had a Zubia body cam and then Sergeant Aaron Estrada body cam.
Oh, you're correct. I have a note on the Zubia in-car video, but not the body cam. So please go ahead.
I think it might be easier to do the Zubia body camera first. This only has up to 39 seconds is where the dispute is. We've agreed at this time to mute all audio on the Zubia body camera after the 2-minute 50-second mark. The only issue is to mute any radio traffic before the 39-second mark. So if we wanted to review that right now.
All right. All right, that's the 39-minute mark.
Second,
I'm sorry,
A 39-second mark, Your Honor. Oh, I think you said minute.
Yes, that's the 30, I'm at 40 seconds right now.
Got it. I believe there's a statement given over radio traffic, essentially saying He's armed and not going to go down without a fight. Contained in that, we would first off have a similar argument to the one I made before, that this is not a hearsay statement, as it's not being offered for the truth of the matter asserted. Rather, it's establishing communication that's taking place, and in the context that it's taking, it's describing the actions that they took on that day. If it were considered a hearsay statement, I believe it, and I have some case law, Pickett versus State. I believe this should qualify as a present sense impression exception, wherein an officer is stating something, an event or condition that's taking place, and then immediately after Zubia is perceiving it. So an alternate argument would be that it would qualify, even if it were seen as hearsay, as either present sense impression or excited utterance. Excuse me, that's Texas Rules of Evidence 8031, I believe.
Response, Mr. Seeloff?
Judge, we would argue that it is hearsay, and it is not hearsay made by someone with personal knowledge. It's hearsay being reiterated over the radio, which is, it's also hearsay in that respect. And they are offering it for the truth of the matter asserted. They're offering it to say, hey, he's armed and dangerous, and that's what they're offering it for. And so we would argue that it is hearsay.
Said it too.
And it's actually double hearsay, because we don't know where the officer, we don't even know who was making the statement. And without that, we can't cross-examine the audio to find out where they got that. We're going to argue that it is hearsay and it is inadmissible.
Well, I'm a little confused because that very same statement is in the Baker body cam video before 729, and defense had no objection.
Your Honor, when you were watching the video, we did not hear anything. And that's why we were okay with it. When you were watching that first video, I don't know if maybe your microphone wasn't picking it up, but we were not hearing it. And that's why we were thinking maybe part of that had already been redacted. That's why we said that particular video we were okay with. So
Yeah,
I
made a note of it because I thought you would object to it.
And absolutely, but like I said, as we sit here now and you watch that, we did not hear it. So I'm thinking maybe we have an issue with our communication, our Zoom communication. We could hear every once in a while little bits of sound, but we were not hearing apparently what you were hearing.
I will, response, Mr. Marable?
Just reassert my previous argument and make a note that I do believe that the person from which Mr. Estrada got the information, Officer Estrada got the information, he is under subpoena. He is expected to be there on Wednesday in order to testify to the fact. And I would leave it at that.
No.
Well,
Estrada needs to,
and
tell her, hold on a second.
hold on.
Estrada needs to be able to say why it is that what he knows when he gets out of the car and this guy is coming towards him.
Okay, and Estrada needs to be able to say what he knows when he gets out of the car, when the defendant's coming towards him, Your Honor.
Who makes that statement? Is that dispatch saying that the statement's armed, that the defendant is armed and dangerous and won't go down without a fight?
They received the information, I believe, from Texas County deputies and from Oklahoma and Texas County, who had received the information from a witness at prior to the evading at the casino.
I'm going to allow it for that reason. I mean, it was very clear that they were, or it appeared to me that they were taking shots at the defendant. But both of these officers had heard that on their radio, so I will allow it. But of course, defense, you may clarify that it's not being admitted to prove that he was in fact armed and dangerous, but that's what the officers had heard in acting and were acting in response to that.
And then again, Your Honor, I just would like to reiterate, that's what the officers had heard. So that, and they were going on it as the truth of the matter asserted. So we're going to, and that's the gist of our objection in that respect.
Right, so noted. What is any objection to is that the only objection to the Zubia body cam?
That is, from my understanding, Your Honor.
All right,
And Judge, I guess we would, on that prior, the Baker body cam, we would like to make that same objection to that part, which obviously we were not hearing that when you were playing it. And that would have been our objection on that. So we would just like to make sure we don't waive that objection as well.
yes, I am taking your objection to be to both. And if that objection is raised at trial again in front of the jury, then I will allow it not as a truthful statement, but as one that the officers are acting in response to.
Thank you, Your Honor. I believe we have one left. I don't have written communication from defense counsel on that. This would be, but they talked to me briefly about it concerning Estrada's in-car video. I think they would probably be at better liberty to explain to you what redactions they wanted from that specifically, better than I would, since I don't have written communication and wouldn't be able to say exactly what they do or don't want.
All right, Mr. Seeloff or Mr. Sally, what are your objections to the Estrada video?
Your Honor, the radio traffic, it's all the same radio traffic, just coming in on 3 different radios, is my understanding.
I see.
Is that
So-
right?
So that's going to be your only objection of the Estrada video, is that statement that the suspect is armed and won't go down without a fight?
I think so, Judge.
Again, I'm going to assume that you will raise this objection at trial. I will do some research. I'm not saying I won't change it, but my inclination now again is to allow that in so the jury can see why the officers were acting as they were acting.
Your Honor, I guess it's also, we object to it being played on all 3 videos because it's redundant each time. It's the same thing being played 3 times. Just coming in through different radios.
So is your argument that the repetition is prejudicial?
That would be another argument, Judge, on at least 2 of them.
You know, I see no reason to play it 3 times.
Your Honor, I guess it would be the state's position that would be an objection they could raise at trial.
Yeah, there you go. That's if you want to raise that objection at trial, then Mr. Sally, then please do.
Thank you, Judge.
And I think that's all we have, Your Honor, unless I'm missing something from defense counsel.
Anything further from the defense counsel?
No, Your Honor.
All right. Then court will be adjourned and we'll see you at 8:30 in the morning.
Thank you, Your Honor.
Ricardo, can you hear me? Give me a call.